All right, good morning. Let me go ahead and call the Thomas Warnick matters. These are 24 CR 1913, 22 CR 1296, 22 CR 1381, and 21 CR 15060. And present in the courtroom today is Mr. Warnick, representing himself, and also for the DA's office, Ms. Ratner, please.
Joe Ratner for the people.
All right. And good morning to both of you. The cases are scheduled, the three cases, 22 CR 1381, 22 CR 1296, and 24 CR 1913 are scheduled today for kind of a status at this time, with the possibility of proceeding to a motions hearing later today if necessary. I've reviewed those three files and I don't see any motions that are pending. Mr. Warnick, did you have any motions in those cases?
I plan to file motions pending your permission to access the court and send these motions to the court, because you have previously restricted my access to the court as a condition of my bond, so therefore I've not been able to address that until now. So I have motions ready to submit. I have one right here, paper copy. I have the rest electronically. I don't know how to proceed.
What kind of motions are they? Could you give me an idea?
There's some simple motions for discovery, basic stuff like the request to disclose witnesses, the resubmission of all the motions that Judith Labuda suppressed in an effort to basically essentially obstruct justice. I got the motions for Pleasant to have you return my property that you confiscated from me illegally. I have a motion for you to recuse yourself. I have a motion to file sanctions against Joe Ratner for his defamation of my defense. Simple motions like that I feel appropriate.
In your own estimation, Mr. Warnick, did any of these motions that you're either proposing or you have attempted to file, do you believe they'd call for the presentation of testimony from a witness?
Absolutely. I have one particular motion specifically requesting witness testimony from an individual I know have to violate my civil rights, or to be able to provide testimony about the conditions, the totality of the circumstance that I'm afforded by the nature of this case.
And what are the grounds for calling these witnesses? Just basically
The fact of the matter is that a false police report was filed against me in my home of record. That is a proven fact. I have submitted video evidence that supports my story. I have not been able to access the police reports, as all that is being suppressed by Joe Ratner, as he claims my defense is a conspiracy theory. He's not allowing me to have a fair chance. He's been extremely prejudicial. What was the question again?
Well, one thing I'm trying to determine is whether or not I need to recall the case at 1:30. I'm not sure that I would be able to because of the lack of notice.
Because you have specifically violated my civil rights. You have obstructed justice. You have held me as a prisoner under false charges at excessive bail that you acknowledge yourself, in which I was confined to solitary conditions where I was not allowed to communicate. We had a specific hearing on bond where we had established that I had been very amenable to the court in the time frame to allow this to progress, and that I had been lied to. I was not able to get bond, as we had discussed. Ian McDavid had given me a false sense of my entitlement after you had posted that, where I was not allowed to post bond for myself. That is not something that they do at the jail. And so you therefore kept me in jail under these harsh conditions, where they were depriving me of basic communications and sanitary conditions, where I was deprived of medical care for my service-connected injuries. So you are absolutely going to have to face the issue that you violated my civil rights, my constitutional rights of Colorado and the federal government. And as a result of your decision, which was very poor, because you didn't take the time to listen to me and to acknowledge what I had addressed, when I specifically said that these motions were suppressed, they have been done under suspicious circumstances. as in I had hired a lawyer, Dion Custis, to represent me. And the details I'll go into, but we had a falling out, and I had asked him to withdraw it for 3 weeks because of his dishonesty. He was publicly censored by the Wyoming Supreme Court for dishonesty and candor before the tribunal. I fired him, and at his withdrawal hearing, Judah Buddha and Victoria Ismo, I believe, conspired together to allow the public defender office to withdraw, only to file a motion to withdraw the next day. They cited in their motion a conflict of interest between the public defender's office and a victim, alleged victim in my case, which is Jay Grant, a former prominent member of the public defender's office that Danica Buck's direct actions protected. So yes, in the light of the false police report being used against me to confine me to jail for 13 months, where I spent 7 of those months in a mental health hospital, where Kyle Green, the psychologist, said that I was possibly paranoid and delusional based on the true facts that a false police report was used to justify keeping me in jail with the specific language that because I had used a gun against the neighbor, I was too dangerous to release into the community. Now, Special Prosecutor Joe Ratner over here, he's not been paying attention to the case very much because he's been having his assistant Keegan Doheen do most of the work. So he's not been interacting or addressing any of these concerns. I've been very adamant that Judith LaBuda falsely accused me and defamed me in order to justify keeping me in jail. And I'm allowed to finally address that. And that's what some of these motions are in line with. So I would really like for you to make an order allowing me to submit these motions to the court electronically so I can get this on the record. And I have the motion for you to recuse yourself of all of my information fully documented in this motion.
Have you made an attempt to file the motions and
You
you've been told not?
specifically said-
No, listen to me. Have you actually made an attempt to file these and a clerk has told you we cannot accept these?
Based on the language that you told me, and I searched on the internet for ways that I could circumvent contacting the judicial staff, because you guys had said specifically that I violated the protective order against Jay Grant by contacting the court. Therefore, you and Ian McDavid made a special point to state that if I hadn't contacted the judicial staff specifically in this court for any reason, you would instantaneously revoke my bond. So that has been a grave concern that I've been trying to address. I've done everything I could to figure out how to address filing these motions by you putting me in jail. Because at this point in time, Joe Ratner over here claiming that my defense is a conspiracy theory, I don't know. I have the Colorado Commission of Judicial Discipline claiming that I have a difficult time understanding the reality because they are unable to find evidence of a concurrent federal case. But I have the evidence right here of a non-prosecution agreement with Greg Holloway and Matthew T. Kirsch of the federal district for a concurrent crime for which this is a deferred case of the original case. So I quite understand this case and have competency evaluations wielded against me as an actual weapon to silence me is very offensive. My service to this nation should at least grant me the benefit of the doubt when I speak upon things.
All right, let me, first of all, Mr. Warnick, address some of this with getting a response from Mr. Ratner about especially discovery issues and things of that nature. Mr. Ratner?
Now, of course, Mr. Warnick is entitled to discovery. In our office, the general procedure for pro se discovery is they either call our office or come down to our office in Castle Rock and request discovery. Then that discovery is prepared and the pro se defendants are notified within a couple of days to come pick it up. In this case, I don't have any notes in my file that Mr. Warnick has made any request for discovery, but if I receive his address here today, I can make sure that the discovery is mailed to him at his residence, so I can do that for him.
May I address that?
You may.
He has a duty and an obligation, as per the Brady disclosure, to provide me no later than 30 days after my appointment of attorney, as you did, which no later than 30 days, he had a duty and obligation to ensure that I had the full discovery. He has failed to meet that. Therefore, I am filing sanctions against him for his failure for the Brady disclosure. He has systematically obstructed justice in this case, and I have laid out the groundwork through my motions to sanction him through the Supreme Court for his direct defamation of my character in my defense. I have not been able to let that go, that he has said that I'm wielding conspiracy theories as a defense, where I have lived this is my truth, I am the only one that's keeping up with the facts of this matter. I am going to prove that at trial. You know, Joe Ratner over here wants to point out in previous conversation that I had mentioned that it was not a wise decision to go to war with someone of actual experience with war. And to that effect, my motivation and dedication to see this through to trial has never been stronger. When I face adversity as a combat veteran, I push through it. I don't back away from it. I'm going to see this through.
Mr. Warnick, are you willing to give to Mr. Ratner today an address to which he can send a copy of all your discovery?
After 2 years, Joe Ratner doesn't know my home address, just for the record.
Well, I think the safest
I would
thing
be
to
more
do.
than happy to provide the place I lived in for the last 8 years, the same place that he's filed search warrants for. So I'm not understanding how his failure to do his obligation as the special prosecutor means that I have to go leaps and bounds out of my way. I don't think that's the way that the Supreme Court ruled when they was discussing the Brady disclosure. And I can go through a couple other points if you want to give me a lot of time to, but he has failed to meet his duty and his obligation to fully disclose all exculpatory evidence and any evidence he intends to use at trial. He has had more than 30 days to meet that obligation. I've been waiting patiently. I don't know his contact information. I'm not allowed to contact the court by your court decision. Your court decision to both restrict my access to the court and force me against my will to represent myself are going to be of a significant topic of discussion when I prove for a fact that Judith LaBuda bared false testimony against me in order to justify incarcerating me. That is a true fact, and I'm going to prove it. I'm going to prove it just like I proved there was no weapons of mass destruction in Iraq by digging every piece of stone. I have 47 motions that I've diligently crafted just to fight this case. And I feel each and every single one of them justified, since this is the first bit of advocacy that I've been afforded since the 6th of September 2001 when I initially took a plea deal in this case. I am afforded the totality of the circumstances as my defense. I believe he has failed that duty and obligation, and I'm requesting you right now sanction, admonish, and/or censor him for his failure to meet this critical and pivotal constitutional right that I sacrificed my life to ensure.
Well, that request will be denied. Mr. Warnick, well, let me ask Mr. Ratner. Obviously, there are a lot of pleadings in the files filed both by counsel representing Mr. Warnick and by Mr. Warnick himself. I haven't dug through them to determine whether or not an address is listed, but do you have an address accessible?
I was looking for that right now, Your Honor. I do have an address, 1539 East 12th Avenue, Pueblo, Colorado.
Is that your address?
That's incorrect.
All right. Would you be willing to give Mr. Ratner a correct address to
I'll
which he
write
can
on this
send
post
discovery?
note if that's appropriate.
That's
and
fine.
I will make this accessible to him if that's.
That's fine, and Mr. Ratner has a business card containing information about how Mr. Warnick may be able to contact your office. I'd appreciate that, or if you can give him a sticky note as well with that information.
I will
You
do
can
that.
exchange sticky notes, and then you can have that flow of information. Hopefully will begin and continue as needed.
You know, I'm handing Mr. Warnick a note with my name and my email address on it.
All right, and it looks like he's done the same for you.
This is not a business card for the record.
It's not a business card, it's a sticky note, I recognize that. And you have the same, Mr. Ratner, a sticky note with contact information?
I do.
All right. All right, then I would expect obviously there to be that flow of information. Frankly, I should make comment on the fact that there have been attorneys come and go from these cases over their life history. And during the time that a person is represented by an attorney, discovery obviously would go to the attorney and not necessarily to the client or the defendant in this particular matter. So let's get that flow started so that all proper information can be submitted. Mr. Warnick, there was an order entered back in February of this year, and that order came in the 22 CR 1296 case. I believe there's a similar order in the 22 CR 1381 case, which talks about the acceptable methods for filing pleadings. Apparently some emails had been sent in with pleadings attached to the division. And you need to understand that there is kind of a division of labor in the court system. There is a division which is headed by the judge presiding over the case, and there's division staff associated. We do not accept pleadings directly into the division.
What is a pleading?
A pleading is anything that's being submitted in written form, a motion to recuse, a motion for sanctions, anything you might want to file is what's called a pleading. Those would go in through the clerk's office. The clerk is a separate person. He or she runs a number of other clerks. They're located on the first floor of this building, for instance, and they accept all of the submissions, all the pleadings that come in from whoever. They have to review them to make sure that they're proper pleadings, they have a proper place to go, things of that nature, and then they send them electronically to the court itself for a ruling. Judge Labuda back on February 26th of 2024 indicated that in the event that you became self-represented at some future point, at that time you were represented by counsel, any pleadings that you file must be filed in room 135 down on the first floor of this courthouse, or filed by U.S. mail to an address that she provided there, the Lindsay Flanagan Courthouse, 520 West Colfax Avenue, room 135, Denver, Colorado 80204. So that's an order that's been standing, and that restraining order that issued in the case prohibiting you from having further contact with Judge Labuda, for instance, or staff, only applied to the court, not to the clerk's office. So I'm sorry about that confusion.
The communication that I sent to the court was through the one communication that I knew, which was the clerk's office, which is that specific communication which was prohibited.
All right, and I'm just telling you right now.
Get away from this. Your decision to block my access to the court is on record. And so that you're saying that when Judith Labuda suppressed my motions with the obstruction of Victoria Ismo, that she had made some sort of point to tell me the proper way to file motions. But I was in jail when those letters came in. I haven't had time to fully review them. And with your poor decision blocking any and all access to the court, I had no choice but to wait until today. So therefore, you need, hold on.
Sure.
I just hit the button to stop it. I don't know what's going on. Oh, pardon me, that's a whole different device. Under normal circumstances, that would be my alert to say that's the day starting. So I feel like because your decision to effectively obstruct justice and restrict my access to file motions, coupled with your involuntary waiver of my counsel, because I had requested my attorneys to advocate for me, and they chose not to do so, which I have thoroughly addressed in all my motions. I feel like you need to recuse yourself for your constitutional violations of my rights effective immediately, because you did hold me in solitary confinement at excessive bail. You refused to address any issues because the public defender's office, and you knowingly knew that they was fully well trying to withdraw. They had submitted a motion to withdraw. They came in and argued, and you said, no, you are going to represent this client. And did they advocate for me? Did they submit any evidence on my behalf? Did they communicate with me? They did not. They came in here and said that I had sent threatening emails to the public defender, which is unfounded and libelous and defamation of my character, especially pending these false allegations, and you allowed all of that through your poor discretion. I stood up before you and tried to thoroughly address what had gone wrong, and you refused to investigate. You silenced and suppressed me. You upheld the poor decision to keep me confined. You didn't allow any advocacy. You didn't follow through with any of your orders. I was held in solitary confinement where I couldn't even use the phone to contact my family, as detailed in over 100 grievances that I submitted while I was in jail under cruel and unusual conditions, where I specifically argued I'm not allowed to use the phone. When I am allowed to use the phone, these specific numbers, like to the Department of Veterans Affairs and the Office of Civil Rights and to this court itself, were restricted. And I filed grievances to that effect. I filed grievances saying I wasn't allowed to use the phone. I wasn't allowed out of my cell for months at a time. I wasn't allowed hygiene. And this was all under your discretion, holding me at jail at an excessively high bail that I could never even afford to come close to if I sold everything I own. And we still have to deal with you making a very poor decision that allowed you to steal my vehicle. I am still without a vehicle because you made that possible. You held me at such excessive bail that they had sold my vehicle before I was even allowed to touch a phone. They kept me in solitary confinement because of you. When I addressed that, you said, not my problem. You specifically said, I do not handle situations like that. When specifically pre-trial was saying, you specifically are the only one that can address that. Ian McDavid didn't make any effort to advocate on my behalf to allow me to leave my house to go get essential medical care. You know, I am still underneath a plea deal from both the federal government in the form of a non-prosecution agreement and an actual plea deal with the state of Colorado, stipulating directly that I am going to get mental health treatment as a result of a HIPAA violation by Robin Maurice Williams, the first person the court mandated I go see for mental health care, leaked my medical information and my court documents to the public that I live in. She was sanctioned by the Department of Regulatory Authorities. Therefore, in the federal case, it was sealed because of this action. I could pull up the entire case history of that event being a true event where my HIPAA information was violated, disseminated into the public, and Joe Ratner is over here saying that my defense is a conspiracy theory. When the fact of the reality is I'm the only one telling the truth in this case. You have grossly affected me by your poor decision, your inability to grasp the most common logic. If I didn't have a gun that day, then how did Judith Labuda convict me on 4 October? There is a conviction on my record that the Social Security is withholding money from me for because a conviction was filed that was underneath Judith Labuda. What is really going on with this circus that you call a court? When I asked for advocacy, when I have a document from the Social Security Administration, and I said, hey, Ian McDavid, the Social Security is saying that the court has filed a conviction against me. What can we do about this? And he says, I'm not going to address that because Michael James Spear is giving me everything I want. His direct quote, you are giving him everything he wants, so he's going to disregard everything that I want. And wherefore you state that you think it is your belief that I want to have some sort of personal relationship with these attorneys, which you are wrong. I've never wanted anything but the truth and advocacy from any of these attorneys. And for my pursuit of holding misconduct accountable, you have decided these things against me, which are going to be proved, and proved through meticulous effort on my part, the discovery. I was thoroughly and brutally beaten at the Colorado Mental Health Hospital by a deranged lunatic named James Claremont. There was no effort for Judith Labuda to even know about this because Danica Buck refused to communicate with me. So I was getting beat up And at that institute, on the 19th of April, I'll correct the record on the date, but there was a fire at the mental health hospital that I survived. This was not a little fire. A Navy veteran with pyrotechnics experience set the entire unit on fire. As far as I know, the wing is still under complete renovation right now because the totality of the destruction the fire caused. And because I was not allowed adequate eye protection, I could not protect myself from the fire. And I literally had to be rescued. And these are all things that were done to me by Judith Labuda because she defamed me by accusing me of using a weapon against my neighbor. So that's not true. Therefore, everything Judith Labuda did to me is a gross violation of all my constitutional rights, egregious, and Danica Buck supporting that. We proved in court that I didn't have a gun. You guys got a lot of apologies to be issuing because she did claim that because I had a gun, I was too dangerous to release into the community. I didn't have a gun. That was a false accusation. Well, I want Joe Ratner produce that police report. Well, I want the Pueblo police produce that police report. What are they hiding? We all know I uploaded the video of the truth. You can hear the police in their own words saying that I was telling you the truth and that I am right. There's no charges. There is a criminal code to prosecute false police reports. And I am the victim of a police report because this man, Joe Ratner, claims that my defense is a conspiracy theory. Nobody will give me credence. I've been defamed and nobody will take me seriously because nobody will take the first step into investigating my claims. Laura Manager was my court-appointed attorney. I did not hire her. She was also Glass and Maxwell's attorney. She abandoned me to her needs of a high-profile client. And her lover, Jay Grant, when she confessed to me that they lived 2 doors down next to each other and they have had a relationship since they both worked at the public defender's office in 2002. She confided to me with this braggadociously, and that's how I know these things about their involvement and how she used that special relationship to suppress me, to silence me. I had fired her previous to the 9 December 2021 court date, but she came back from New York and with Jay Grant ordered that I receive a competency evaluation, which has delayed this entire proceeding for 3 years now because she chose to use her friend, which I will prove extensively at trial because it is the truth. These are matters of public records and I have not even gotten into the official records yet. I've already proved so much. I would like to file these motions electronically. I need you to say on the record that you're rescinding my restriction to contact court staff for official and legitimate reasons.
Not doing that.
So how am I supposed to file motions?
I've already explained to you the difference
Well,
between
I-
courts.
You're going to have to accommodate. You're going to have to
You need to be
accommodate-
quiet for a moment. I've already explained to you the difference between court staff and the clerk of court. You may
You need to
contact.
accommodate my service connect. You need to
Stop,
accommodate by
stop,
providing me that
stop,
information in writing.
stop
I don't
talking.
know, and I can't.
Well,
I didn't
then,
take
you know,
notes. You need to
you don't want to
provide
listen
that
to me,
information.
fine. If you don't want to listen to me, fine.
I tried
I'm trying to
listen
answer
you.
your question.
Say again?
I am trying to answer your question and you are not
need to
letting
it in a
me
way
do that.
I can
Stop
you need to accommodate-
talking.
Under the Americans with Disabilities Act, you need to give me some sort of basic accommodation for my service-connected disabilities. I'm asking that you provide me that information reasonably in some sort of way that I can read it, because you saying it is not helping me based on my traumatic brain injury. A severe traumatic brain injury where I specifically had a number of problems with the short-term memory. So this is all verified through medical records of the Department of Veterans Affairs and its service connect. So all I'm doing is asking for a little bit of accommodation for my sacrifice.
Will you accommodate me?
You stole my car and put me in jail at $100,000. I've been more than amenable to you.
You know what, Mr. Warnick? I authorized the issue of a warrant for your arrest in 24 CR 1913 yesterday because you're not in compliance with the conditions of your pretrial release supervision.
I don't understand.
You are on pretrial release supervision.
Right.
You are not compliant.
I don't understand.
You are not keeping your ankle monitor charged.
I tried to contact Greta, she's not contacting me back, I'm trying to charge it. I've been distracted, I've not been getting contact back from her, I didn't know what to do. I've asked for a replacement, I don't know what to do. You leave messages on these places, they never get back in touch with you. I don't know, there's a specific court order from Jay Grant saying that they're supposed to accommodate my service-connected disability through phone calls, and I've been trying to manage this with Greta, saying I can't get this thing to work. And I'm here in court, I can show you the device, it's not been destroyed or anything, I can't get it to work. I don't know what the problem is, but I tried to contact Greta, but she's not responding back to me, she's sending me automated. We can go through the phone, she hasn't contacted me back, she hasn't sent me text messages back. I got a million things going on, and I don't know what to do. So I understand that you're frustrated with me, but I'm here, I'm not a threat to the community by any degree. I'm trying to manage this.
All right, Mr. Warnick, will you let me talk? Thank you. As far as the warrant goes, I'm gonna simply quash the warrant, vacate it, but I am going to order that you contact or you go over to Greta's office before you leave the area today. And if you can't talk to her, you need to talk to whatever support staff she has, explain the difficulties you've been having and ask for some relief from them. And tell them that the court has recognized that you have indicated problems and the court is giving you some leeway because of those problems and is not ordering you into confinement. All right? Secondly, I'm gonna go ahead and give you a copy of this February 26, 2024 acceptable methods for filing pleadings. This contains in written form the address. You can come on up.
See that?
You can come on up and get it. This will tell you in writing where to send things. And I am not prohibiting you from having contact with the clerk of the court, just with the staff. I am not prohibiting you from having, I've never prohibited you from having contact with the clerk of the court.
I can't wait to see the record of that so I can fully examine your direct communication in that regard, is gonna be the point.
As far as any pleadings you have, you can get them submitted. It doesn't sound to me like any of these pleadings will necessarily impact the ability of these cases to proceed to trial in a timely fashion.
I disagree.
As far as your motion to recuse the court goes, insofar as it might reference things previously mentioned in court, the court has previously filed or indicated that it would not recuse on this matter. But I'll be happy to examine any written pleading you submit in regards to a request to have me recuse off the case, and I'll enter an order. This does have to be legally compliant, and I cannot give you legal advice about what legally compliant means. You'll just have to work on what resources you have for making definition on that point. The motions hearing scheduled for this afternoon at 1:30 in the 24 and the 222 cases are vacated, so y'all don't need to come back this afternoon at 1:30. The cases are scheduled, all of them scheduled for respective trials. I think the first one we have queued up for trial is 22 CR 1296. It's scheduled for trial on January 13th and 14th with a pretrial readiness conference on January 6th at 8:30. And the other two cases that are scheduled for trial, those are cases 24 CR 1913. That is scheduled for a trial on February 3rd. I believe that the case 22 CR 1381 is scheduled for trial on February 24th. So those are the matters we have scheduled on these cases at this time. So Mr. Warnick, you have to get your pleadings submitted to the court in appropriate fashion. I will indicate, I'll do a preliminary ruling on motions. If I feel that Mr. Ratner needs to file a written response to a motion, I'll review your pleading. If I think it's appropriate, I'll send a preliminary order out to both of you indicating Mr. Ratner will have a period of time to file a response to the pleading. Oftentimes, pleadings will be submitted to the court that, frankly, I can rule on without a need for a reply, but I'm not prohibiting Mr. Ratner from you filing responses, replies to anything that Mr. Warnick may send to the court if you would like to make a record on that particular aspect. So, Mr. Warnick, just as you're requesting from the court, pleadings be submitted in written form for you to be able to read them and review them. I also require that you submit things to the court in written form so I can read them and review them. And another thing is that makes a better record too in the event that there is a need for an appeal to a higher court. There will be pleadings, there'll be documents, there'll be orders entered by the court that are available for review by that appellate court without having to reconstruct the record or anything of that
Are you
nature.
specifically requesting that I submit paper to you, or
No.
can it be electronic?
Electronic.
Okay.
Can be done electronically. And I'll keep an eye on the file, and just as soon as the
As we're
plea,
sitting here, I've already submitted all those motions for the record. I submitted a zip, and I filed each motion individually, because I preemptively prepared for this.
all right, let me,
So just for the record, I went ahead and filed all those motions to 02 courthouse, this one.
all right, let me give you just, I can give you a shorthand on that. If you think a pleading's been submitted and it exists in the court file at this point, the electronic file, you don't need to do it again. But I would need you to basically tell me, you know, way back in February of 2024 or some other time before that, I submitted a pleading to the court. And
You
because
did?
you, no,
Are
I'm
you
saying
talking
you
about the
did.
original?
You may have submitted a pleading to the court. And the court didn't rule on it because you were represented by an attorney at the time.
Which I was only represented because mysteriously they appeared, and I would like that addressed, the communication between the public defender's office and the bench, how she even knew that that hearing was a thing, how she came in at the last second just to be able to prevent these motions that would have addressed her violations of my civil rights, only to withdraw the next day. We're gonna have to address that eventually. I think the jury's gonna find it very interesting that that is a true fact, that Judith Labuda and Victoria Isma obstructed justice, and I believe they conspired to do so.
Mr. Warnick, let me explain just a little bit about how the trials are gonna go in these cases. Trials by necessity are devoted to attention to charges the prosecution has brought against you. That means that a lot of information that you've mentioned here today may not be presented to the jury for consideration.
Under this statute, retaliation against a judge, I am constitutionally afforded the totality of the circumstance, which you can't deny me. I'm allowed to say everything that Judith Labuda did to me with her decision to defame me and use false testimony. You can't get away
This
with that.
will be subject to objections at trial and rulings by the court.
You can't object to the truth. That's just a simple thing. You can't object
Mr.
to
Warnick.
something that is a true thing, which is already a matter of court record.
Despite the
These
fact,
things that I'm discussing are already a matter of court record, so you can't just obstruct something that's already on the record.
Mr. Warnick, despite the fact that I believe that you're actually not hearing anything I'm saying today, I'm going to explain to you. The fact is that when a matter proceeds to trial, there are rules of evidence, there are rules of law that apply to those proceedings that I am bound as the court to apply to those proceedings. So oftentimes, an individual representing themselves will come to court with an expectation or belief that they'll be able to present a lot of information to the jury, but they find out that the court will not permit that to happen. Whether or not the court is correct or incorrect in doing that will be reviewed by an appellate court, if appropriate, after the jury has reached a verdict in the case. And so that's how things play out. You may have an expectation about what will go on within the four walls of this courtroom, but I am required.
I've already cautioned you on the record about your violation of my civil rights, and you made the special motion to say that, yes, that all of these things are on the record. And a thorough examination of that record is necessary, which is my motion for discovery, is that it contains pivotal evidence. I don't think that's something you can just deny, is my basic request for discovery.
All right, I think, again, I just have a feeling that I am just not being heard by Mr. Warnick in any substantive matter whatsoever.
Well,
So
I
I'm
feel
gonna
like
call a
it's better.
recess on these cases and just indicate that we will reconvene on the matters on January 6th at 8:30. And I'll just see everybody back at that time with the bonds continuing to that date and time. Mr. Ratner, you've been sitting quietly and patiently. I'll ask you if you have anything you'd like to add on the record at this time.
Your Honor, is there a deadline for Mr. Warner to submit his motion?
Well, we're past the deadline for filing motions, but I'm gonna just indicate, since Mr. Warnick indicates many of the motions have been filed already, and that there perhaps are a couple other motions he'd like to file, that as long as they get filed within, say, 2 weeks of today's date, I'll consider them. Frankly, if they get filed after that, I feel obligated to make some sort of notation about them, whether or not there is sufficient time for the court to address them before trial. For instance, if they get filed on January 5th, I might have trouble addressing that for a January 6th proceeding. But I'll just take his pleadings as they come in, and I'll try to give you as much advance notice with a deadline for filing any responses for pleadings that I think are appropriate.
Understood. Just a few more matters. I don't want to put the court on notice. I might be filing a motion under Colorado Rule of Criminal Procedure 43, just given the circumstances. The motion would essentially be requesting the court to make an advisement to Mr. Warnick of that rule, should that become something that is relevant to trial.
I think you better do these in writing, because as Mr. Warnick has indicated, he needs to have things in writing to read them, to understand them.
Any pleadings I file, I intend to send to the address provided to me by Mr. Warnick today and to the court. With respect to the hearing on January 6th, is the court requiring in-person appearance?
That's a pretrial readiness conference, so I think in regards to that, I'll permit electronic appearances, so the parties don't have to travel all the way up
Objection.
here. Yes, sir.
I would like to ensure that it is an in-person hearing.
You want an in-person
I feel
hearing?
like Joe Ratner has
That's fine.
neglected this case.
I'll make it.
Virtually bullshit his way in the same way that Judith LaBuda in her virtual hearing suppressed my rights to in-person hearings as part of the criminal procedures of Colorado. I'm entitled to, as you should know, that you're violating, and that should be sanctioned up for violating the Brady disclosure that you know of, because you know for a fact that you have your obligation to provide discovery. I don't have to follow your rules, you have to follow the Constitution in providing discovery to me. Let's get that on the record.
It'll be
Now, I
an in-person
can't file further motions without knowing what evidence there is against me. And despite Ratner's beliefs, I've sent hundreds of motions, hundreds of emails, hundreds of requests for discovery. The contentious point with Dion Custis was that he refused to give me discovery, saying that he had spoken to Joe Ratner. I had emails from him saying that he spoke to Joe Ratner and received discovery. And I would find out from his assistant he had not received discovery. So yes, I've been very adamant about receiving the full scope of the discovery. I made that abundantly clear in all the emails that you have. And you know this, I told you in county court I wanted discovery, I told you in this court I wanted discovery. That is all on the record, which I'm gonna use in your sanctions hearing.
I'll be here on January 6th.
All right, in-person proceedings on January 6th then.
And the final matter is, Your Honor, this is a sort of a weird issue. I have a new district attorney being sworn in on January 14th, but this trial commences on January 13th, and it could go for a couple of days. What does the court have any expectation in terms of filings and making sure that, I guess, come Tuesday morning, it's sort of a weird situation. Because I know all my colleagues on January 14th are gonna be sworn in after Mr. Brockler is sworn in. So what sort of pleadings does the court expect me to file to make sure that I'm the special prosecutor on this case?
That's an interesting point of fact, the creation of the new judicial district, and obviously the need for you basically being recognized as deputy district attorney working for the newly elected DA of that newly created district. So I guess what I would indicate is that I think the case law indicates that there can be some kind of recognition of difficulties of getting an oath in an appropriate fashion. Let's just have you do the best you can. You have to wait until Mr. Brockler is sworn in order for you to receive an oath of office as well. But if necessary, we can do that electronically before we proceed further on the second day of trial. But we'll do what we can to accommodate that need to make sure that we're all constitutional officers.
Okay. I have nothing further for the court.
All right, Mr. Warnick, got any last words you'd like to say before I call a recess on these
I
cases?
just wanna reiterate for the record that I did submit electronically those motions. I wanted to address in the motion hearing, the two vacated. Also, obstruction of my freedom. You basically said I could file motions, but you can vacate the opportunity to hear them. So, let's address that.
No, the afternoon was going to be devoted, if necessary, to any, motions
Rather
that
than
may have.
have this, that's a sample motion that he's gonna have to, deal with. Or the court can have it, you know, that is your motion for you to recuse based on all the evidence and your constitutional violations against me.
Mr. Warnick, if you ask
I
me.
find that your ethics are seriously in some sort of way that you cannot recognize that your decisions have grossly been inappropriate in violations of standard constitutional protections. And that you're so adamant that you think you're right in this situation, well, I'm gonna prove that you're wrong with the truth. And that I should have never been put into this situation in the first place, if not for corrupt judges abusing their authority like what you have done. I hope you don't sleep very well at night, because you did this to come at a sacrifice very life for this nation. You took away the rights that I helped guarantee with my sacrifice. I hope you feel really ashamed of yourself for your actions of feeling like suppressing the truth, obstructing justice, refusing to hold this special prosecutor accountable for his violation of standard constitutional rights, such as the Brady disclosure. Something that is paramount to every defense is having evidence against them. Now, we're 3 years into these charges and nobody's provided me discovery yet. And when you made me officially the attorney of record, he had a duty and obligation. And you think that that's okay for him to violate. He knew my address. It was very simple for him to make that effort that he knew was a duty and obligation. But you can see through his feckless effort in this case, that is the status quo that we are living in, where you guys can literally obstruct justice and you think I'm not gonna tell the truth about it.
Mr. Warnick, if you ask me a question, if you give me time to respond to it.
I'm making statements of
Can you do
fact.
that? Can you do that for me as a matter of politeness?
I would like you to just recuse yourself,
All right.
because I
I'll
don't see
free-
how you could produce a fair trial underneath what you have already done against me.
I'll look at your motion when it's submitted.
It's, as far as I'm concerned, it's submitted. I'll thoroughly resubmit and submit until somebody confirms to me that they have received it.
And I'll call a recess on these cases, and we'll see everybody back on January 6th at 8:30. Emailed them to you. Apparently, the pleadings, Mr. Warnick, have been resubmitted by you, but again, to the wrong location.
What is the correct electronic email?
The piece of paper I gave you gives you the directions about where to submit those. Can you
Because
read that?
These are the same, that's the same electronic email address that accepted my motions previously, those same ones that Judith LaBuda suppressed. So how is that same email not sufficient this time when they have already accepted motions from that email address?
Can you read the document I gave you?
Does that include the email address?
I'm not going to accept pleadings by email. You have to follow
You
those
told
directions.
me earlier specifically when I asked you if I had to submit things in paper form, you said, no, they can be electronic.
Mr. Warnick, you are not listening to me.
I'm only addressing what I thought you said. I specifically asked you for
You are not listening to
clarification. Do I need to submit everything in paper? And you said, no, it can be done electronically. So therefore, could somebody provide to me the correct location for electronic filing for these cases?
Read the pleading.
Yeah, I've read it, but it
Go
doesn't.
down to that location before you leave the building today and ask that particular clerk where you should send pleadings electronically, all right? And of course, don't forget, Mr. Warnick, that you need to go to Ms. Aldridge's office, try to correct this confusion that exists, perhaps on her part, perhaps on your part, perhaps on both, and get yourself into compliance with pretrial release.
Understood.
You're free to go at this time.